somewhere along the way, we're going to need to discuss topics that you guys would like to see us cover in the next few months, and maybe the meeting format. So, if anybody has any ideas, just for a few minutes here, if you want to shout out something that you'd like us to cover, something that you'd like us to cover again. Anybody. I personally, I'd like to have Dave cover, syndication. The other possibility is we could have two speakers. We could have somebody speak for 15 minutes, and maybe somebody else speak for 45, or we could even do it, yes.
Did you ever cover the lease, rental lease? Did you ever hear of that? I wasn't here for a period of time last year, I'm not sure if you ever covered that.
We could probably do that. I don't think we did, but we certainly a good idea.
I don't know how long that take, but it's covered.
One of those things you could, if it frees over to 15 minutes, you could spend 3 hours on it.
Appealing the taxes.
Okay. I've done it a few times, and it's usually worth it. Yes.
Same thing he mentioned, assessment of fuel taxes. What are you finding with that? Is it usually worth it? I found it very worth it.
Probably done it 4 times, and every time it was very well worth it, yeah. Did you measure those, Tom?
Mm-hmm. It really just, it's very fact specific. Depends on having a good appraisal, what you're assessed for to start out with, knowing the common level ratio and figuring out what you should be assessed for. And usually if you go in with a good case to start out with, then you get some relief. It's pretty rare that if we lose at that level, it's worth appealing to the next level because that gets expensive. But that first assessment appeal, a lot of people do on their own. It doesn't cost you very much.
What's kind of level ratio in Lanchester?
1.23.
1.2. Okay. So common level ratio is if you're assessed at 100,000, multiplied by 1.24 would be 124. The house should be worth about it should sell for about 124. So that's the value of it. It's assessed at 100. Chester County, I think it's about 1.8.
1.66.
Is it really? Oh, that's a good number a little bit. So if you're assessed at 100 in Chester County, it should be worth about 166. If you're buying something at 100, it's assessed at 100, you may want to consider it. Anybody else?
Yeah, you can maybe cover, like, the rents keep going up and so forth. Everyone says the rents are going up. So how's, maybe talk about some good ways to increase your rent with existing tenants without, having them all leave.
Anybody else? What do you guys think about the format? Do we do a preview for 15 minutes and then cover that topic the next month?
That would be a great idea. That way it gives you a little bit of an insight what's coming up and prepare some questions maybe.
Even if we just kind of go over the agenda or the topics that we're going to cover, and give
Just
them
a
to think
fair
about.
outline of it, get some good questions.
So a preview.
I think it's working well the way you're doing it now too, but good thought.
Do you guys like the seating arrangements? When the group was a little smaller, I did like the round table and just not think that's working too good. We want to encourage you guys in the back to come earlier, so we'll be talking quiet. I have little secrets up here.
You said there is no secrets.
You're right, the secret is, there is no secret. Okay, anybody else have anything else that they'd like to see covered? I'd like to, like the 1031s, tax exchange somewhere along the way. That'd be something good to cover. Any other topics? Feel free to, just grab one of us after the meeting if you think of anything that you'd like to cover, and we'll write it down and try and get to it. Okay. So I guess that's the eviction process and how to avoid it. Unfortunately, I spent most of my time covering the eviction process, and I just added that how to avoid it, and I probably should have spent more time worrying about how to avoid it than the actual process, because it can be expensive. But since that's what I prepared, that's what we'll go over. you guys heard any of these myths? You guys think they're all myths, or you think there's any truth to any of them, or?
I think they're all
I
myths.
think they're all false.
I think I've heard every one of those.
Yeah, there's another one that's on there. You know, I don't have a lease. I didn't sign anything. Well, you may not have signed anything, or a tenant may not have signed anything, but there's still a lease. It just doesn't happen to be in writing. It's a verbal lease. And actually, you can have verbal lease. The only time you have to have a written lease, I believe, if it's over 3 years. I would highly suggest you always have a written lease. But if you don't have it in writing, then you just, by default, you have to follow the Landlord-Tenant Act, and that's not always where you want to be. It's absolutely best to put it in writing. So, let's see, it takes 90 days to evict a tenant. Well, it certainly can. You can do it in less time than that. Sometimes, and we'll go over a time limit, sometimes that's about how long it takes. People don't really treat it as a business. It can take up to 90 days. But that's longer than it needs to be. It takes longer to evict somebody with children. It really has no bearing, whether they have children, whether they're pregnant. The tenant's personal circumstances really don't have anything to do with the eviction process. It is possible that you could have an extremely sympathetic judge, and he could give them extra time. It has happened, doesn't happen often. You don't have a whole lot of recourse other than appealing the decision. You just sit there and smile and give the extra 2 weeks, and hope they leave at the end of the 2 weeks. Let's see, it takes longer to evict someone in the wintertime. A lot of people say that, and there's a little bit of truth to that. If it's a mobile home, between September and April, the notice requirement, I think, is 50 days to 30 days. But really, in residential, apartments, houses, really, the time of year really has no bearing. Some people think there's tricks to evicting somebody. No, you can try and evict somebody, we get them out of there in 10 days, or they'll go in, they'll change the lock, or they'll shut up the water. You definitely do not want to do a self-help eviction. You get yourself in a lot of trouble that way. You can talk to them. You can trick them into moving. Great. That's the best thing, a little bit of legal intimidation, well, you can let them know that the eviction is going to be on the record. When we're looking to rent places to new tenants, if they have an eviction in the last 3 or 4 years, I probably wouldn't even consider them. It's 5 or 6 years, depending on the circumstances. But, you can try that and say, well, if you guys just leave, we don't have to go to court, take time and money. If you can get them to leave, that would be the best thing.
The question on that is, would you ever be able to get a judgment on back rent on something like that?
Absolutely.
Okay.
And you can actually even attach the wages. And you might want to talk to Tom or somebody who's more familiar with that, because if they don't have a good job, it's probably not worth it.
Mm-hmm.
There's a lot of rules and regulations. If they're an iffy tenant to begin with, you can't take them to within 10% of the poverty level, whatever that is. But you can do it, and it can be done. So you can get a judgment.
You can do the judgment without an eviction?
The judgment without an eviction. I don't, Tom. You get the judgment, and whether they leave with an eviction, you still have the judgment.
Yeah, you could get a money judgment, and then I guess if you didn't transfer that money judgment to the county, then it's not gonna show up on our record.
Mm-hmm.
Let's see here. The last one is you need a lawyer or property manager to file for eviction. You definitely don't. You can do it yourself. But there are times when it's nice to have someone who's really familiar with the law, especially if they appeal it. If there's a bankruptcy involved, sometimes you get really technical. So, like I said, I should have probably spent more time talking about how to avoid getting to this point, as opposed to actually going through the eviction. And some of those things, well, we cover those right now. How many people have rental properties already? Does everybody have a written lease? very good. That's the first thing. Screening your tenants, I would make them fill out an application. You want that information. I would photocopy their driver's license, I would photocopy a pay stub. You know, there's just so much information you can get, and you can start seeing, you know, if everything looks good and lines up, you know, you keep moving forward. When you start seeing little red flags, or even little orange flags, then you need to check more. When you photocopy the driver's license, is it a driver's license, or is it work ID?
I always do that, but it's usually when we're signing the lease. Do you ask for that
With the app, you do it with the application.
with the application?
Yeah.
Okay.
Because if my famous saying is, there's probably a reason for that. You know, when they come in and they don't have a driver's license, they have a state issued ID, there's probably a reason for that. But when we run the credit criminal eviction report, you know, it'll show up if they've been busted for driving without a driver's license, or maybe they've been busted 5 times for driving without a driver's license. Does that mean we're not going to rent a property somewhere with no driver's license? No, we probably have dozens of people literally without driver's license. But it's a little bit of a red flag. You know, what are they doing for a living? Are they driving? You know, is it gonna create a problem in the future? And there are just so many things. You know, where were they living before? Were they there for 6 months? You know, why did they leave? You know, one of my most entertaining questions is, why did you leave? And you'd be amazed at some of the answers you get. You know, why did you leave your previous? You know, some of it's unbelievable. But you know, yeah.
Where is it on record if they were evicted? You just take their word for it, or is there actually a site that records of an eviction?
There is. We kind of run them all together now. There are a few sites. There's a free site out there that you can go. Technically, you're not allowed to use it for housing or employment. So you can kind of go out there and browse it, but you can't use that as a reason to reject them. But you can certainly do some more digging. It's pajudicial.com or something, but it's a free website. You have to go in by county. So you have to go in Lanchester County, your name, date of birth, and then go to Chester County and check them all. But there is a free resource out there, and I can find that for you, but you don't want to deny them housing because of that.
Don't you use some kind of search to,
Well,
that is, why is the one
we-
legal and the other one not?
maybe because it's not updated. You know, the one that we use, you know, we print out the credit report, the eviction report, the criminal report. I don't know, if it's certified, verified, it's okay. We can actually deny somebody with that one, but the free one, you know, says right on there not to be used for.
Yeah, I saw that already too. I was just
Okay.
like, why? Why can you use the one and not the other? You know, they both have basically the same information.
If you do find it on that one, then maybe you want to go to the pay site,
Uh-huh.
it's pay the $15
That's what it is. It's, somebody was doing some lobbying there.
The reason to reject them. So, yeah, there's just, you're almost looking for reasons not to rent to them, you know? That's almost the way you have to look at it, because a lot of people do it the exact opposite. They look good, smell good, you know, and they have the money. That's another thing. Oh my goodness. They're telling you they have the money. I got the money, I got the money. They tell you that more than once, there's a problem. You know, of course you have the money. It costs money to rent this place. And another one, and I have to be careful how I say this, but the worst thing you can say to me before you hang up the phone, I'm telling you, I hate to say this, but it's, God bless you. I've had people come to showings with Bibles in their hand, you know, or telling me that they have to go, well, I gotta get out, I gotta go to, you know, my church group meeting tonight. Man, when they're wearing their religion on their sleeve, we don't deny them, but boy, I start looking into it. You know, why are they telling me this? Why are they giving me this information? Now, some people just do it out of force of habit, you know, they just always do it. Some people, they're using it as a crutch, you know? So that's, you know, that's just another thing. You just kind of need to be aware of what they're saying, what they're doing, and why. You know, what is their intention? And if you do it for a while, you kind of start to read people, and if you just be quiet and let them talk. I mean, I've got fooled, and most of the time I get fooled when I wasn't listening. Give them 10 or 15 minutes, and they'll shoot themselves in the foot. They'll tell you something they're not supposed to. I had one was a minister, he was coming in from Montana, and it was a really nice house. It was $2,200 a month. And he's telling me his church is in Elizabethtown, somewhere on the western edge of the county, and he's in the very eastern edge. So right away, I'm like, okay. And he's driving a Lincoln Navigator. And he's there looking at the house, and it's for his wife and his kids, and he's got this 30-year-old with him. And we're looking at the house, and I'm just not getting that warm and fuzzy feeling. And we'll look at the master bedroom, and this is the housekeeper. And she's making a comment about the master bedroom not being that big. And I'm like, well, you're the maid, basically what you get, how big the master bedroom is. And it just kept going and going. And then before we left, I got everybody's phone number so I could get back to them because they were out of state. And I called his wife, and it sounded good, and kids, and everything kind of meshed until I called their previous landlord. When I called the previous landlord, they put on the application, it's the same number that they gave me at the showing. So I asked for whatever this name was. It was a very unique name, easy to pronounce, but it wasn't Smith or Jones. But in other words, when you heard that name, that was her clue to put on her southern accent and say that, oh yeah, they live here. So I let her go for 15 minutes, and I'm looking at my phone, and it's got her name and number. It's like, I just got it from you yesterday. You were in Pennsylvania, and you were the maid. Now you're telling me that, oh yeah, you rented to them, and they were the best tenants. And I mean, they just literally just give you a bogus name and number, filled out all the inaccurate information, and they just go through. So anyway, yeah, really.
How did that happen?
I called them on it, and they were silent for about 10 seconds, and then, well, the other thing, before I got to that point, was he transposed two numbers on a social security number. And we were kind of moving forward, and I said, well, we can't, because your social security number isn't matching. He goes, well, that's been my social security number all my life, I know it. I read it off. Yeah, that's it. I said, well, we can't rent it to you. Social security number doesn't match. Well, what's the number again? So I wrote it again. Oh, the last two numbers are transposed. I transposed them, and then, his excellent credit wasn't so good. But it's still, there was no real deal breakers there. We were still kind of moving forward with the process. But as these red flags come up, the more red flags you see, the deeper you want to dig. You just kind of. And that was an interesting one, to say the least. Okay, so let's go through the actual eviction process. If you didn't take an application and you weren't paying attention and have a tenant there that's not paying, what do you do? You've never been through this process before, so go to Google. Google how to evict someone in Pennsylvania. Man, I pity you. I was on there for hours, and at least half the information was completely wrong. 80 or 90% of it was at best misleading. Just scary. So, what I did was I put the actual chapter and verse. What do you call this, Tom? What's the terminology there for the tenant? What's that?
The notice to quit?
No, the chapter and verse thing, whatever that section of the code.
Oh, it depends on the act.
Well, whatever it is, that if you go to Landlord-Tenant Act and you go to this chapter, verse, paragraph, whatever, it'll give you very specific information about what we're going to talk about today. So I was trying to be as accurate as possible, because there's some places that they're going to tell you it's 30 days. You have to give someone 30 days for notice for money, and you don't. You do have to give 30 in some cases.
Quick question, where do you find that, the Landlord-Tenant Act, where you will find those topics?
If you have access to a computer, yep, absolutely.
Just Pennsylvania, County of Pennsylvania?
Pennsylvania. Yeah, and then 1951 has been the same for 60, 70 years.
Yeah, the Attorney
There's
General's
some
website.
modifications, but
Attorney General's website in Pennsylvania.
yeah. And so if you go to that website, all the information you find there is going to be accurate. It's the ones where the people who think they know what they're talking about is scary eviction trouble. I mean, I must have for 5 or 6 different places where they said when you get a notice, you got to send a certified letter. I think it actually says in the act that may not be in enforceable. Certified letter is not considered notice. So there's a lot of misinformation, out there.
So just to be clear, you don't need any notice to, to file for eviction if you have it in your lease, is that correct?
That is correct. We should probably talk to Tom about that. I've had judges tell me that for money judgment, that's fine, but for a breach of the lease, they said that that's what they call it, it's not, you can't give that right out. It's not a waivable right. Is that true?
I've never had a district justice on that.
Because I don't think it is. The non-waivable rights deal more with like security deposits and stuff. You can't waive the right to, you have to get a security deposit back in 30 days and those sort of things.
Just like the 10-day thing, you could put that in the lease that you can evict them in 10 days if you need to, and it wouldn't fly because that's what you call a non-waivable right.
Exactly. So there are some rules that you have to go by, no matter what your lease says. Okay, so there's a problem. You're not sure what to do. Maybe you do go to Attorney General's site to read it. It's kind of confusing, but you're trying to follow the steps. So what's the first thing you do? Well, hopefully, there actually is a violation. If it's a verbal agreement, it could be difficult to prove. It's a written agreement. The violation would be they didn't pay that. That's usually number one. So what is the violation? What did they do? What did they not do? They have not paid rent. That's one type of violation. Maybe it's a 1-year lease. The lease is up and the terms expired, and they haven't left. Or maybe wrong blank. They break the lease for something other than money. That's another type of violation. So you need to figure out what the type of violation is, because that's going to dictate to you the type of notice. So, is there a lease? Yes. If it's in writing, let's follow the requirements of a lease. If it's not, then you can kind of default to the landlord tenant act. So, since the first thing we need to do is get proper notice, what is proper notice? Proper notice is either posting the property, so you give them their pay, rent, or quit, or your violation of the lease, your term is up, and physically post it on the property. I usually just put it right on the front door, and I actually don't usually fold it over. If I fold it over or put it on there, then I take a picture of it where you can actually read it, and then I try and back up again and take another picture if the house number's there somewhere, just so you know that it's posted and you're at the right house. The other thing is you can hand it to an adult on the property. So as far as I know, that's it for notice. You either post it or hand it to an adult. Is there anything else, Tom? Is that?
Certainly posting is the requirement. I always send them regular mail and certified mail. For the guy that says, hey, it fell off my door, I never got it. Well, I also send a first class mail and certified mail. I've never had a district justice give us a hard time if he did all three of those.
Right. Because if they don't sign for the certified letter and you send it first class, if it doesn't come back, to you, it's assumed delivery.
Oh, the notice, do you have to give a notice if they're 2 months behind their rent, or 2 days, or whatever? You have to give them a notice before you go and file a complaint?
If it's written in the lease that they waive the right to notice, you can just go. Once they break the lease, so they didn't pay rent for April, and it's in the lease that they don't have, that they waive the right to notice, you can just go and file. If they waive the right to notice.
Okay.
So that's one thing you probably want to put in your lease. Okay, so proper notice. Landlord Tenant Act is very clear what's considered proper notice: posting the property, serving an adult, certified mail. So now, the other thing you have to be careful is you can send something certified mail and they get it signed for, and you can go to district court and everything's fine. I mean, I've actually had a district justice. We had a property that's in Lanchester County, it has a Morgantown address, and I actually filed in Berks County with Judge Glass. Not to speak bad about him, he's a good man, but he actually allowed the hearing. Now, if the tenants would have said, that's the wrong venue, it's the wrong place, we're in Lancaster County, we have to go before Judge Stolzfus, I'd have to start all over again. Lucky for me, he let it go. So some of these things that I'm telling you, you might say, well, I did that, or I didn't do that, and it may work. But what I'm giving you is trying to give you is the letter of the law, and if you follow this, 99.9% of the time, you'll be okay. So certified mail, Tom says, you do all three. You post it, send certified, first class, you're definitely covered.
But we don't have to do any of that if the tenant waives the right for the notice, right?
Correct.
Because the first thing I'll do is go to district justice.
File. Yeah.
I don't.
So if you don't have a written lease, you have to give notice.
Correct.
If you have a written lease and it doesn't talk, if it's silent on the matter of notice, you gotta give notice. If you have a written lease and it says 3 days, you gotta give notice. If there's anything there other than them waiving the right to notice, you gotta give notice.
So your tenants, the first notice that they would get would be a letter from the court?
Right. I mean, it's not a surprise to them because at that point I
Yeah.
communicated with them, but no certified letter or anything like that.
Yeah, and
So is there a reason you would not put that in your lease?
That's what I always wondered.
just being uninformed,
Okay.
just not knowing any better. I mean, you can always give them notice, you can always give them time to stay, but when it comes time to get rid of somebody, you want as many shortcuts, so to speak, as possible. So, if it's for non-payment, which is probably gonna be over half, of non-payment of rent, and the lease, if they didn't waive the right to notice, you need to give them 10 days. And 10 days always turns into 11, but you have to give them 10 full days. So if you file, what's that, the 8th, you can't go to court on the 18th, you gotta wait till the 19th. You have to give them 10 full days, so on the 11th day, then you can file district court. So if it's for money, they want you to be able to get the district court quick. So 10 days notice.
Weekends count for that, right?
Yes. Falls on a Saturday, I don't think you can file on Monday because they couldn't have filed on Sunday, so you have to give them the full 10 days, and it can be Tuesday. 15 days for breach of lease or a term. The term would be if the term was expired, if it's for 1 year or less. So if you have a lease for 1 year or less and they break the lease, you have to give them 15 days notice. Now, if it's for more than a year, if the lease is for, 2 years, 3 years, whatever, you have to give them 30 days notice. 30 days notice, you're gone. The security deposit's gone and you haven't even started the process yet. So, if you have a 2-year lease and you don't waive the right to notice, it's very expensive. File a landlord-tenant complaint. Dave looks like he's falling asleep.
We're good.
All right, this is for Dave. Let me see if I can make this work. This will explain. No, it won't explain this. I need internet. Oh man, I forgot about that. I'm so used to Wi-Fi.
What were you
What was that? Abbott and Costello, who's on first. I don't know if you guys are familiar with that, but it's a hilarious routine. The baseball players are who and what, and they're talking back and forth, who's on first.
I got a hotspot.
Mr. Technology. And it almost felt like that the first time I went to file. And then we're talking, 20 years ago. And on purpose, the clerk was just not very helpful. Let me know if that worked, Dave. Some of these guys.
I used to have a hotspot.
You don't?
Forgot to put them back on unlimited data.
were you using to me? They took me off. And I didn't know like 2 months I was off. And then,
This probably goes on for 15 minutes. And it really is hilarious until, you know, you're the one on the other side of the counter and you go there, you go, okay, I have a tenant that's not paying rent, I want to get rid of them. They're, kind of look at you, because you're not using the proper terminology, you're not saying what they're used to hearing. And, well, well, I want to get the property back, I want possession. Oh, well, do you have a judgment? No. Well, how do I get a judgment? Well, you have to have a hearing, and it's like, you're asking all these questions, and then, when Adam Costello says, third base, well, that's like, well, we don't give legal advice, so you ask a few questions, you get to the close, well, we can't give legal advice. So, when you go there for the first time, if you're prepared and you have some of the information, use the right terminology, you have a lot better chance of trying to get them to help you. So the first thing you want to know is, or you have to know is what you're going to do with your filing. You're filing a landlord tenant complaint, not a tenant landlord complaint. You're not looking for possession, not yet. You're doing that later. So you're going to file a landlord tenant complaint, and they will give you the paperwork. And you have to fill it out. And then they're also going to need some information. They're going to need to know how many tenants are there, how many defendants, because it's more to serve, if there's more than one. And then there's the price changes from 0 to 2,000, 2 to 4,000, 4 to 6, 6 to 8. So depending on how much you're filing for, it depends on how much the fees are. So there's never one set fee. It's how many defendants and how much are you filing for. So once they have all that information, then they'll give you a figure, you write them a check. And the it's going to cost about $130, $140. Sometimes the clerks are helpful, sometimes they're not.
You had said something about they want to know the names of the defendants.
Mm-hmm.
What if, say, a couple moves in and at some point down the road, their parents move in, or brother and sister, and you don't have any idea who they are?
Well, then they shouldn't be there. I don't know, they're squatters, but typically it's the name that's on the lease. They're the ones that, they're the ones signing up. And bringing someone else to court that doesn't, that isn't on the lease.
But don't you, if you get a judgment to evict, isn't it pertaining to only the people that you have on the judgment? What if you have somebody squatting?
I call the cops. I love calling the cops. I mean, I say that half seriously. Obviously, you never want to get the police involved, but to the extent that there is even the potential for the police to get involved, and if they'll do it, it's quick, it's free. You don't have to pay anybody else to do it.
And they can take somebody out?
Yeah, those people that are
Okay.
there, they are trespassers. Now, what happens a lot of times is the police show up, and as soon as those people say, I have a lease, or I'm a guest and someone else has a lease, then the police will say, this is a civil matter, we're out of here, your landlord needs to go to district justice. But it didn't hurt anything to try, because they are trespassers.
Yeah.
Once you make it a civil matter, you can never go back and make it a criminal matter.
Okay.
And that civil matter thing, that's kind of like the clerk saying you can't get legal advice, the cops easy out.
That just just heard a podcast just lately where the guy was flipping a house and somebody changed the locks. This is another state. Somebody changed the locks and moved in, and then they had to go through the whole eviction process.
Yeah,
And it was a
heard
house that they was ready to sell.
horror stories like that. Yeah. That's the other thing. Once you start the process, if you're gonna get rid of someone, you really shouldn't stop. Years ago, wow, way back, had a, just, tenant was there for 2 years and then things really went downhill. That was just bad. But anyway, I had the constable out and he changed the locks, and somewhere along the way, there was a conversation between the police officer and the tenant, and he told her that, I don't remember what it was, if she would have done such and such, you know, she could have stayed for a while. And he's like, she's like, well then, you know, let me back in, you know, just for 2 days or whatever. It's like, no way. The constable's here, the locks are changed, you're gone. I don't care where you're sleeping tonight, because if you let them back in, there's like physical possession, legal possession. You don't want to give them possession again. If you give them possession again, you might have to start the whole process all over again. You know, so once you decide you're going to get rid of somebody, you're definitely going to get rid of them. Keep marching forward. So yeah, the clerks may or may not be helpful. Get the form filled out, pay your fee. Then the next thing that's going to happen is in 7 to 15 days, you're going to have a hearing. And you need to be prepared for the hearing. You want to have a copy of your lease, absolutely. You want to have a copy of your payment history, and you want to have exactly to the penny how much they owe you. The judge is going to ask you how long the lease is for, if there's a security deposit, how much of it is rent, how much of it is late fees. We charge 10% late fees. We don't always get away with 10% late fees. The judge says, you know, $2 a day, $60, that's it. Okay. But the 5 times before we went to court, you know, the tenant paid the 10% late fees. You know, just because it is written in the lease doesn't mean that's always the way things are going to go once you get to district court. But I would definitely encourage you to have late fees, have some kind of incentive, you know, for the people to pay on time. So yeah, you want a copy of your lease, payment history, and any other supporting documentation. If you're saying that you know, they broke the lease, they're loud and obnoxious, and you have a copy of the police report, you want to bring that. You want to bring that. It almost seems like the person with the most documentation wins, because the judge is going to hear both sides of the story, and then wherever they make a decision, they want to have some kind of facts. You know, a lot of times I'll go in. There's some district courts will have landlord-tenant day, and you know, there might be 8 or 10 hearings. And sometimes I'll go in earlier, sometimes I'll stay late if there's an interesting one coming up. And you'd be amazed how many people show up with nothing. I mean, just nothing. You know, they haven't paid me rent. I want to kick them out. And if the tenant has anything, if they have any kind of documentation, the landlord, landlord's not always going to win. So let's see, how does this work? If, go ahead.
Are you saying you can sit in at other hearings or?
Yeah. Find out when your landlord tenant hearing day is, and you can sit in there and get a good education. So, if no one shows up, if no one shows up, the tenant wins by default. If the tenant shows up and the landlord doesn't, tenant wins by default. If the landlord shows up and the tenant doesn't, the landlord wins by default. But if you both show up, then you can have a hearing. But if you both don't show up, the tenant wins.
What's your experience where one tenant shows up, husband shows up, wife doesn't, or vice versa? Do you ever get default judgment against the other one?
No. Never really thought to pursue. To tell you the truth, that's a good idea. So if you have judgment against one and not the other,
My theory is always if the constable comes to kick the wife out, the husband's going to follow. If the husband gets kicked out, I'm not so sure.
Okay, so where are we? The hearing. I mean, it can be intimidating the first time you're there, but the judge will typically kind of walk you through the process. He knows it's small claims court, he knows you haven't been there before. you will usually speak first, and you'll just tell them, you know, why you're there. You know, tenant didn't pay March's rent, they didn't pay April rent, they told me they were gonna pay, they didn't. You know, I gave them the notice, so when the notice is required, that's why we're here. And then he'll ask them some questions, and, you know, the tenant might want to cross-examine you cross-examine them to get the facts, but usually it's really short. I'll bet you 50% of the time, the tenant just said, I owe them money, but the reason is, and the judge will usually listen to the reason, if it's only a minute or two, and I say, well, I'm sorry, but, you know, we're here for the money. Fact is, you owe them money, admitted that you owe them money, fine in their favor. 1 out of 20 times, the judge won't make a decision like that and there. If there's something he or she needs to look into, they have 3 days to make a decision. So sometimes you may leave and not make a decision, and they'll learn to their decision. So yeah, preparing for the hearing, attending the hearing, we could probably spend a lot of time on that, but you know, it's only for those 1 in 20 times. Yes.
You said something about something in the payment history. Is that payment history of the previous month?
Yeah. So you might just, you know, if they've been there for 6 months, I'd bring on 6 months. You want to show the history, especially if they've been late or if they've been getting a little later. And then the judge is also going to want to know, like I said, you know, how much is rent, how much is taxes. The other thing is, when you file for money, there's a remedy, and the tenant can pay. And 9 times out of 10, now 99 times out of 100, the judge is going to do what's called pay and stay. If you've never been to court before with that tenant, the only reason you're there is because of money, and if the tenant said, "Oh, I want to stay, I have money," they're staying. I've never got possession of the tenant is willing to pay. The judge will always give them a pay. So because it remedied the problem. The problem was it didn't pay. It remedied the solution. We still have a lease.
And at that point, who pays for the $130, $140 you already paid?
They lost. I mean, they lost, but they say that they're paying for it. Yeah.
So the tenant reimburses you for that?
Correct. Yeah. So that would, you know, you would make that when the judge, you know, finds the judgment's going to be for rent, whatever late fees that he's allows, and then court costs. So if they pay that amount, they're staying. So
What if they would pay partial,
that's up to you. If you take a partial payment, they're staying.
but the judge doesn't require, they would have to pay in full for,
That's what I would suggest. You can take a partial payment.
no, I'm saying,
Well,
if you wouldn't accept it, the judge can't say you have to take partial.
No. It's up to you.
They would have to come up with the money right then.
Once again, it's up to you. Once you have the hearing, there's, what do we have here next thing? Attend the hearing, file for possession. Well, before you can file for possession in the court, there's a 10-day right of appeal. You can appeal the judge's decision, and the tenant can appeal the judge's decision. So really, for 10 days, nothing happens. On the 11th day, you can file for possession. So there have been times when the tenants say, well, I can pay it on Friday, I'll pay you on Friday. Okay, so I told the judge, great, you know, we're still gonna do everything as if they're not gonna pay. But if they do pay, on Friday, sure, they can pay, stay. So that's what's called pay and stay. Because you can't do anything for 11 days anyway. So if they come up with the money 11 days, great.
Because I was just wondering, you know, how do you know if you can believe them? If they say, well, I got the money.
If they don't pay you, then on the 11th day, you file for possession. So, let's say you didn't know any better. You have a tenant that's real jerk about paying, they're destroying the property, they've been there for a year and a half, it was a 1-year lease, the term is up, and you go and you just say, well, they haven't paid me, and so you don't know anybody, you fill out the form and you say, well, they haven't paid me, you know, they owe me $2,000. That's the only thing that you put on the complaint, and they pay, they're staying. Unfortunately, you can't, I don't know, can you amend the complaint? I know you can amend the amount, but I've had judges tell me that you can't amend the complaint.
For what purpose?
If it's the defendant's name, address, or why you're there.
Even
require new service.
Okay. So, yeah, larger service, so basically you're kind of gonna be starting all over again. So if you really wanna get rid of the tenant, you don't wanna just put on there, you know, for money, because if you satisfy the money, they're staying. So if you wanna get rid of them, you know, they break the lease, you wanna write that in there, because the lease expired. There's really no defense for that. If you wanna get rid of them and the lease is expired, and you gave proper notice, there's really nothing the tenant can say or do. Time is up, or lease it to them for a year. Years come and gone, they're still there, you want them out. I mean, that's the best case and easiest way to get rid of the tenant.
Do you have to give them a notice if you're not gonna renew the lease?
What's a lease say? Yeah, if like if your lease, like on the Pennsylvania Associated, the FAR lease, there's 2 blocks you can check. One where it'll automatically go month to month, and one where it automatically terminates. Or if there's language in your lease that says this is a 1-year lease and terminates at the end of this period, then it's done, the time's up. But you also have, you know, it also could say something in there about notice. So if it automatically goes month to month with 30 days notice, you're going to be given a 30 days notice.
So what happens if you have a 1-year lease and you check the box where it says the lease terminates after the end of the year, and all of a sudden you're in the 13th month, and do you still have a lease, or is that lease expired and you're pretty much without a lease?
Lease is expired.
The lease is expired.
Yeah.
So then you have no grounds against them unless you go away with a lease.
Oh, no, you still do, because at that point, they're holding over, they're on default of their lease because they were required to get out December 31st.
Okay.
Well, let's get a question. If the lease is expired and there's no lease, then does that, you just default to Landlord Tenant Act, and anything that was written in the lease is now?
No, because you're still suing them under their lease. Yeah, even though the term is expired, it doesn't mean people's obligations under a lease is expired. Those are 2 different things. A lot of times you'll enter into a lease that's effective today when I sign it, but the term might not start for another month. And the term might end in a year, but that doesn't mean that they're still not responsible for their obligations within that term.
Someone knows more than you.
Do you have a recommendation to have wording in there to automatically roll over a month-by-month basis? Because I have a situation now where the year's up, they want to move to Tennessee, and they want 4 more months to the middle of summer, so they want to just do a 4-month lease. So that's why we wrote it up. We did a 4-month lease, but even that's not set in stone. They may want another month or 2 after that. Can I do a rollover month-by-month case without rewriting these leases all the time?
Yeah, in that case, I probably would have just done a month to month, you know, even though they want 4. I probably just said, well, you know, I'm not gonna kick you out next month or 2, but let's just do a month to month lease, you know, because if you do anything stupid, you get them out. You know, you can start the process in 1 month anyway. But yeah, you can have 4-month lease, 6-month lease, 1 year. We typically do have it automatically renew from month to month after the first year. You know, it keeps us from being in that situation where the lease is expired and they're, you know, and they're kind of in limbo. So we typically do a 1-year lease and then we have it automatically renew month to month after that. This time of year, a lot of times we'll try and do a 15 or 16 month, kind of push it to June just for the school year. You know, so they're there till, you know, till June. And you can adjust the lease how you want. You really don't want your leases ended in November or December. November, December, January is really tough.
So is there a separate sentence to just include is to do an automatic rollover? I mean, what wording do you put in just to?
Yeah, probably right underneath where the term is, you know, the lease starts at such and such a day, you know, ends on such and such a date. This lease will automatically renew, you know, for 1 month and require 30 days written notice from the tenant, 30 days written notice from the.
So there's no paper transaction at that point. The year's up, it's in the contract for the lease, so there's no paper transaction.
You don't need to do
it. It's still
anything.
extended month on month.
Right, and it could be that way for 5 years. There's actually probably a lot of people out there that are on a month-to-month lease. It just automatically renews until somebody gets a written notice. You always want to give your notice in writing. So let's see. So you've had the hearing, you won. Yay! So you wait 11 days, now you have to go back and see the health clerk again. Give them another $130 or $140. And what you want to tell them now is, you won the judgment, you were there 11 days ago, and you want possession. So they'll give you another, form to fill out, and you take your money, and they're gonna give that to a constable, and then, within the next 48 hours, the constable will go out and push the property and let them know, that there's a judgment against them, they need to leave. He's gonna give them 10 days to vacate the property. If they don't, he'll show up Monday morning at 9 o'clock and forcibly remove them if they're not going by then.
Question on, if they file an appeal on the 10th day, now what?
It's probably gonna be 3 or 4, hold on. That's something I can't help you with. As a real estate, anyone with a real estate license or a broker can represent a tenant in small claims court at district court level. There's a form called 207, it's authorization, representation. I'm not an attorney, but I play one on TV. But I can represent you in landlord-tenant matters. Now, if we don't get the security deposit back in time, that's a civil matter. I'll probably go with you to district court if the judge is nice and let me sit there, but I really can't do anything with civil matters. Landlord tenants, I can do the whole thing soup to nuts. If it's a civil matter, call Tom. Once they file the appeal, they appeal that in the court of common pleas, it's completely difficult, plus you have to start all over again, literally. And that's definitely something, I don't know, what's the quickest, if they just have to leave, but typically you're talking months.
Fortunately, it very rarely happens because it takes a pretty savvy tenant to do it. Or if they're gonna hire counsel to do it, it's not cheap. And for them to appeal, they have to post all the benefits due with the proprietary, and not a lot of people can do that.
That's the word.
Yeah, that's the broke. But in fact, if they're broke, they just get out of the filing fees. But you can still require them to post their rent. In Lancaster County, if they owe you under $50,000, then it has to go to arbitration, and the arbitrators are taking the stance that they can't rule for possession, they can only rule for money judgments. So you have to skip that step and go to the big judge and have an actual hearing. I've never seen one take less than 6 months.
Yeah, and they're still there. Technically, they're supposed to be paying rent to the voluntary, but it's, you definitely don't want that to happen if you can avoid that at all.
So then you would pay him to leave?
Yeah. I've never done that. I can't say I never would. It just completely rubs me the wrong way. I've had Section 8 tenants that rent a place for $1,200, and I'm supposed to pay them, and I'm getting $1,100 from Section 8, and they're not paying their $100. Tom was almost involved in that when we really lucked out. Had a tenant file for bankruptcy. We've been to court 2 or 3 times with a Section 10. I can't believe we didn't lose a Section 8 and then filed for bankruptcy. Well, that's like the short, was in jail. The second or third time, no money. We just filed for possession. Because anything that has to do with money, bankruptcy will stay, and the district justice don't want to do anything about that. I talked them into comedy the mess. The one judge pushed himself, he didn't want to hear, and I ended up somewhere else and talked them into actually securing possession. While the guy was in jail with the bankruptcy, and it all worked out. But it's just one of those things that could have been really bad. So you win. 11 days later, you file for possession. They still don't pay. You meet the constable there on the 11th day, and you change the locks. I have had people still asleep at 9 o'clock in the morning on the day the constable's going to be there. Oh, let me get my stuff. What? A month wasn't enough notice? All these stickers all over your door wasn't enough notice? It can really be frustrating. But the constables, they're not spending the day there. They usually give 5 or 10 minutes, get your stuff, hit the curb, make arrangements with the landlord, get your stuff later. So while he's there, we typically change the locks. If it has 3 or 4 doors, you don't want to be spending time, changing the lock. Grab a 2x4, screw the door shut, screw the door shut, screw the door shut, come to the front door, change the locks on the front door, the property secured, check all the windows and doors. The constable usually walk through it with you if they're still there and make sure there's nobody in the basement. Literally go through every room, close it, then he puts it on there, they go back in, it's trespassing, and they get in a lot of trouble. Or, like we had a couple weeks ago, you know, we're on the outside trying to get in the lock, and she's on the inside relocking the door. Calls the cops. And then when we finally get in, she had a board propped up against the door, and when we finally get in, I think my brother-in-law there, because he was drilling the lock out. We go in there, nobody there, I'm like, I'm still in the living room. I bumped in the console half a dozen times. Okay, you do your job, you can track her down. He looks around, there's nobody there. I mean, we know she's there, she was slipping along, we're on the second story. So we look through, go all the way out front. Here she's out on the porch, she climbed out the window, she's out on the porch trying to break into the neighbors. I closed the window and locked it, called the cops, waited for a cop to show up. She left in handcuffs. And I just, you know, just not,
This is interesting.
not into playing games, you know. And then, you know, it's amazing how many times, well, you know, they start, why do you do this? Or, you know, we're past that. If you've ever got to the point where you have to evict a tenant, you probably really don't want them. Because if they have medical emergency or emergency in their family, they're going to call you and tell you you're going to work things out. If you've got to the point of eviction, you really just want to get rid of them. Get the next person out.
So what happens when you physically remove them and they still have stuff in there? What's the legal?
I was looking at that. You know, there's some things that say 10 days, some say 30. If they give you their forwarding address and they make any kind of arrangements or plans with you, I think they're legally obligated to hold it up to 30 days. If they
I
don't,
recently heard it was changed from 30 to 10.
10 days.
Yeah.
10 days is the maximum.
10,
If your lease says that.
Regardless.
or
Yeah.
or if the judgment says it.
Amber Green said,
That's in the Lanchester.
okay,
That's where I remember it from.
10 days.
It was, but either, where would we find it?
It's Act 129 of 2012.
Senate Bill 887. 10 days.
So there's still a 30-day rule. So you have to give them 10 days notice.
No,
If-
once they're physically removed, you don't have to wait 10 days. for their-
But
What if they contact you within?
if they give you,
Beside the point, they have 10 days.
yeah, I'm not sure.
That's what she was saying. That
There's, if it says on the judgment, it can also say something on the judgment. So that's one of those gray areas where you definitely want to make sure you know exactly what you're doing. If they've abandoned the property, if they're not there, you know, the 10-day thing would probably be okay, and I've done it myself, in less than 30. If they contact you in writing, man, I'm not going into 10 days. You can find yourself in a heap of trouble when they start coming back to you and say, that couch was $3,000, and TV, and this, that, and another thing. You know, you can stick it in the garage of the house, or in one room of the house, and you go about your business, do the rest of the house. But if they
Or
contact
you can put the whole thing in storage.
Yep. And then you can even sheriff's sale it off later. You're not allowed to get any more than what they owe you if it brings more than that. But yeah, that's one of those things I would definitely look into. But it can be as short as 10 days.
You want to be watching them when they come, when we evicted like that, you know, stood there and watched them get all their stuff out afterwards. When in the place, their last act before they left was to clog up all the sinks and turn on all the water.
Yeah. Yeah, there's some vindictive people out there who do some not so nice stuff. Screening, once again, you know, coming back to screening. You know, nobody has a crystal ball, but typically, that's not the first time these people have done something like this. You know, for the landlord-tenant relationship to completely break, it's unusual, but they've probably done it before. I mean, that's, you know, there's a reason, and if you screen the tenants, hopefully you won't be in this predicament. Okay. This is April. Oh, I did. I wrote down like a perfect world. All right, so this is April. You didn't pay rent in April. What are you going to do? fifth, you know, they said, hey, I get paid next week, meaning this Friday coming up, you gonna let them slide, you know, maybe. So, who's got a calendar? I got a monthly calendar. What day is Saturday coming up? Is that the 13th?
13th.
So let's say we give them, rent's due on the 1st. Rent was technically late, say on the 5th. Late fee started accruing after the 5th. Tenant says they're gonna pay, so you wait. We give them another week, so we give them till the 13th. Now, Saturday comes, they don't pay. So 14th, Sunday, you're not gonna do anything on Sunday. Monday, you're real busy, you know, you forget to do it. So the 15th, you run out there and you give them 10 days notice, so you post them on the 15th, you gotta give them 10 days, which actually turns into 11. What day of the week is the 26th?
Right, Saturday.
Saturday. Evening then. So Monday would be what, the 28th? So finally, on the 28th, you know, we file. Maybe the judge is real busy, they can take up to 15 days to give you a hearing. So another 15 days from that, so now we're gonna be somewhere on the 13th or something of May.
Yeah.
He's flipping an awful lot. What day of the week is that? It's the 13th.
Tuesday.
Tuesday, that's a good day. So, have the hearing, and maybe the tenant brings some information with them. The judge doesn't even give you, render a decision for another 3 days. And you gotta wait another 10 days after that, so that'd be another 13. So now we're down around the 26th.
And Saturday again.
And it's Saturday. All right, so then we go to the 28th. They give it to the constable. The constable has up to 2 days to post the property, unless he gives them 10 or 11. So now we're, who knows, we're somewhere in the middle of June. Just because we were kind of lackadaisical what we did. So, and now in a perfect world, if you treat this like a business, how many people here have another business other than real estate? You know, like their businesses, building sheds, whatever. Could you imagine running that business the way some people run the real estate business without having things in writing, allowing somebody to move in without being paid? I mean, you know, if you're building a shed, I mean, don't they pay for the shed typically before they get it? You're not just gonna drop it off. It's okay, I'll see you next week. If I get paid next week, I'll pay you then. No, it's COD, no cash on delivery. So let's say we're gonna run this like a business. Say we've been having trouble with this tenant before. They're not paying, and we're just not messing around. We're done messing around. We're not cutting them any breaks. We're not hearing any excuses. So on the 2nd, he's late. Guess what? Let's just file on the 2nd. So we file on the 2nd. I don't care about late fees. We're working to get rid of them. Tenants say they're going to pay. Who cares? We're filing a complaint on the 2nd. If everything goes in your favor, it is possible that you could have a hearing in as little as 8 days, 7 to 15. So let's just say on the 10th, we have our hearing. We win. Have to wait 11 days before we file for possession. That would be the 21st. And since we really don't like this guy, we're there at 9 o'clock in the morning and sweet talking the clerk and asking if the constable's around and if she can get that to him today. So maybe we get lucky and actually does. The constable actually gets it on the 21st. Posts the property. Where are we at here? Hearing, file for possession, constable posts the property, and then another 11 days from there would be May 2nd. So that's in a perfect world, everything going your way. You can't possibly do it in less than a month. You've got a month and a day. And that's, you know, there are some things there that are beyond your control. It is possible that the hearing could have been a week later. It is possible that the constable could have took, 2 days to clean the property. It's possible that the judge didn't make a decision. So in a perfect world, if you follow all the steps and they waive their right to notice, you can do the whole process in just over 1 month. So if all you have is a security deposit, and there's any damage to the property, kind of already behind the eight ball. So once again, it'd be better to not get to this point.
Quick question on that. If you have in your lease that you have, if you're giving them a 5-day grace period, can you file before that 5 days is up?
I don't know, I think it's up to the judge. Technically, they broke the lease because the lease was inferred. And depending on how your lease is written, if you're giving them a 5-day grace period, probably not. If you're telling them that late fees start after the 5th, probably. I don't know for the time yet. Yeah, because the grace period, you're giving them the grace period, but if just as late fees start after the 5th, they still break the lease, so they're just charging late fees after the 5th.
So you shy away from adding a grace period.
Yeah.
It's late fees after the 5th.
Yeah. And there's no requirement to get any grace period. We've talked about that at the office about, I remember on the first. There's so many government agencies, for whatever reason, seem to pay on the 3rd. It's just cumbersome for us to have. We try and have everything uniform. So on the 6th, when people are late, we know they're late.
So what do you do if, after the grace period, you call her up and ask her, make sure the rent's coming, and she says, yeah, she put it in the mail, and it don't come till the 15th or the 16th, 17th, somewhere around there, and it happens every month.
Well, if you train the tenants from day one, you can avoid a lot of those problems. One of my other things is good fences make good neighbors. And sometimes when somebody has a bit of a property, maybe have 2 or 3 acres, and they don't want the tenant to have the whole thing, put the fence up. Before the tenant's even there, put the fence up. They're never going to know the back acre or 2 belongs to that property. They just know they cut the grass up for the fence. If we had one just up the road in Honeybrook, it was 1.5 acres. They weren't cutting the back acre. And the guy wanted to fence it in with some sheep in there. They weren't cutting it. They wanted a rent reduction because they didn't, they didn't have access to that property now. If that fence was there from day one, they never would have knew and never would have cared. So in the beginning, when you're sitting down with your tenants and you tell them, it needs to be in my hand on the first, not in the mail. Sometimes I'm just rude. I don't care about postmark. That's what I tell them. I don't care about postmark. At least I don't say anything about postmark. I don't care when it was postmarked. It's got to be in the office. Now, depending on how the lease is written up, they may get away with it if it's postmarked, on time. So you have to be careful, but I really don't care when or where or how it's postmarked. I want it in the office. And the other thing is, you can decide how you want to get paid. You don't have to take checks. You don't have to take cash, you take money or certified funds. And if you do that right from the beginning, it's going to be a lot less of a problem if you try and get them to do it after they've got the gone into the bad habit. The other thing you can do is you don't have to get a grace period. If they ask for one, you can say, well, you're gonna earn it. After 6 months of time and payment, we'll give you a grace period once or twice a year if you're a little bit late. Because it's a grace period. It's, in case there's a storm, electricity runs out, or there's an emergency. Some people are constantly paying the 4th or 5th if you give them that. So the best thing is to just train them right from the get-go. And if they break the lease, enforce it.
We had a guy that wanted to be reminded. Apparently he was just not a good bookkeeper, and he was just running late 2 or 3 days. I call him, and he'd always come up, hand deliver the check, and it's all good. Then he actually asked to be reminded, call and leave a message at the day or 2 before his due date. And I've been doing that for about 4 months, and it works fantastic, but it's a pain.
When's the due date?
What's that?
When's the due date?
They will come in on the 1st.
Wow.
But honestly, he's been there for 2 years. He's a great tenant. You keep the house immaculate. He's a great tenant as far as that. So I have no reason for, to pursue anything else. And honestly, he's just a bad bookkeeper.
Hey, if he's been there for 2 years, he's paying rent, and keep it, make a phone call.
That's what phone call.
Yeah. There are some things that you don't, there are some things that just aren't worth fighting over, you know, and in that case, you know, to fight and possibly lose the tenant, absolutely, no reason to do that, you know, call them. But if you can train them as much as possible at the beginning, so they take it seriously and treat it like a business, that's definitely the best.
Another way you could handle it, if you got tired of making phone calls, you could have your wife make the phone calls.
Or Joe would be happy to make that phone call for you for 6% down.
Okay, any other questions about the eviction process? So, I didn't write this up, but let's just go through some numbers. Let's say the rent's $1,000. They're not paying rent. You take the lackadaisical approach and you don't get them out until the middle of June, that's $2,500 right there, gone. Gonna probably be about anywhere from, you know, $250 to $300 in court costs, probably about $130, $140, depending on the number of tenants. You're probably gonna have to do something to the property when they leave, clean it up, paint it. So, I mean, a typical, not so nasty eviction still gonna run you about $3,000. If you're taking your time and holding out. Now, you can ask for first month's rent, last month's rent, and security deposit. Now, that'll help some. The other thing is if they have $3,000 laying around, they're probably a little bit better than the people who don't have first month and security deposit. You can require 2 months security deposit, but after the first year, you have to give one back or just use that rent. But, yeah, screening the tenants, and I would never, ever let someone in without first month's rent security deposit. Because if they say, I got April's rent, you let me in and we'll make payments, you know, May, June, and July, I'll give you, $250 every month. They're broke. As soon as the car gets a flat tire or needs a transmission, they miss 2 days of work, guess who's not getting paid? You. So if they're that broke, we don't even prorate the first month's rent anymore. Like we have people that are moving in this weekend, it's the 13th. We don't prorate April's rent. They pay first month's rent and security deposit, we prorate the second month's rent.
Very good.
Because 5 years ago, 10 years ago, we had people that would want to move in on the 25th. You know, they want to pay $100 for, you know, they would move in on the 28th of April and say, well, I'll give you $100 for into April, here's my security deposit, and then May, I'll pay you rent. Well, once they're in there, you know, you're kind of stuck with them. And it'd be possible that they could move in, not make any more payments, and it's going to take you 2 months to get out. So they're living there for 3 months on basically 1 month's rent. So, you know, if they don't have money, there's a reason. You know, they're going to be the one that's receiving and finding out why. Okay. Anybody else have any questions?
If you want to keep the security deposit for damages to the property, do you need to do anything?
Yes, you do. You need to get it back to them within 30 days, and you need to deduct, all your deductions need to be in writing. And unfortunately, if you're in there doing the cleaning, you can't deduct that. If you have somebody else come in and do the cleaning and they give you a bill, you can deduct that on security deposit.
My wife is a cleaner. Can my LLC pay her and it's deductible?
Probably don't want to go there. Tom Shagan said yes, but if they know it's 30 and they're not going to give you a hard time, you know. If you don't get back to them within 30 days, you lose twice. The rent's $1,000, security deposit's $1,000, and you drag your feet, you know, I don't know, the window's broken, I get my brother-in-law to come fix it, and you wait 31 or 32 days, and they file day one, you're paying them back $2,000. So you want to make sure
That is even if you use the entire deposit for repairs, you need to let them know what it was used for. You need to either return their money or let them know how it was used within the 30 days, right?
Correct. And if they trashed the place, I don't know, we'll make sure this is accurate, but Judge Stolzfus, he had one that was about 35 days, they trashed the place, was $2,000 worth of damage. He had it written up, and he was under the impression that he was only going to have to pay 2 times what was owed to him, but it was 2 times the rent. Have you ever run into that?
Say that again?
There was $1,000 of security deposit, and he had written up, well, not that, he had written up like $800 damage. Gave it to him on day 32 or 33. And I told him it was gonna be a problem, and he thought he was only gonna have to pay twice what was owed to him. But it was twice the security deposit. Yeah, so even though there was, I guess now what if you'd have had $1,000 for damage? You still didn't give him that notice within 30 days.
Yeah, the damages are relevant at that point, the statute says twice the security.
He loses. So yeah, if you don't give him something in writing within 30 days, you're gonna lose. Any other questions? Yes, sir.
Not a question, but remember when you and I first worked together, you warned me, we had the opposite effect. We had a guy that paid 3 months rent up front. He wanted to pay all that rent, he wanted to pay all his rent up front. That's all he ever paid it.
That's all?
That's all he ever paid, we had to pick him into that. He wanted in and he, I got 3 months rent up front, I'm gonna give it all to you once. Yeah, well, as you educated me on that, there was a reason for that too.
It's a red flag, especially this time of year. Income tax checks come back, they're broke, they're getting kicked out. They got a lot of money and they're flush with cash, so they're ready to go. You do have to be careful about that too. If you take too much prepayment, I'd say talk to Tom about that. But technically, well, in a lease, so it's a monthly agreement. If someone pays a year in advance, 6 months later, they decide they want to get out. Other than being a big mess, what happens?
Depends what your lease says. I guess as a practical matter, I've never seen that happen. I'd be curious if it did, but theoretically, your lease could say if they defaulted, you could retain all down money that they paid as liquidated damages. And if your lease said that, you could keep it.
If it doesn't,
You give it back. Just
Yeah.
justice.
yeah, I think so, because it's technically, it's not your money, because that, May hasn't come around yet for me paying, in fact, June hasn't come around yet.
On a similar note, if you were to collect first month, last month of security deposit, and 6 months into the lease, you're filing for eviction because of non-payment or for any reason, if you get them out within that 30 days, if there's no, I guess it would be unlikely, but it could happen that you would have extra money in that last month's rent. And the answer to that would be kind of the same as what you just answered. It would be unlikely that that would happen because usually you're going to be at least a month behind anyway.
Well, then there's a security deposit, but I think it's going back to them, because I don't think you can, at no point in time can you charge 2 people rent for the same space. So let's say they leave and they pay the last month's rent, say today, what's today, the 8th, and they pay for April, 6 months ago, you get a rent it tomorrow, I think you're giving them back that portion of the rent.
If someone were able to do that, I would suggest thinking about, instead of calling it last month's rent, just call it security deposit, and then 2 months of security deposit. Now, if there's extra damages over that.
But then at the end of the first year, then one of those months security deposit has to go back to the tenant at the end of the first year. So that way, if you do the first one, last month's security deposit, on the second year, then you're kind of in a better position.
After the first year, and going okay, you're usually an indication that you have at least someone to do
Yeah,
it.
and that is another whole topic. Security deposits, it really should be in a separate account. The second year, it goes back 1 month. After 5 years, when there's an increase in rent, you can no longer increase the security deposit. For the first 4 years, if rent's $1,000 and they have $1,000 security deposit, if you raise the rent to 11, you can ask them to match out the security deposit. After 5 years, that's it. Whatever the security deposit is, it's it.
When you go to district justice, before the hearing starts, does the district justice often ask you if you'd like a minute to talk with the tenant, work out with you?
It does.
And what do you do?
Depends on if you want the tenant to stay or go, or if there's been any dialogue. A lot of times you can make an agreement, right there, before. Sometimes tenants just need to know that you're serious. And then you can also, if you can make arrangements, sometimes the judge, you don't have to have a hearing. You already paid for it, but you don't have to have a hearing. So if you can work out a deal that you agree to, just make sure you're going to be happy with it. Make sure that you have cash in hand. take, well, I'll pay you, well, meet you out in the parking lot after the hearing, you can file a forget it, have the hearing, and then if they have the money, you can always not file for possession. You know, every once in a while, maybe, you know, people just do things just because they're trying to be nice. And I'm not saying you shouldn't be nice to your tenants, but be nice to yourself. You know, if this is a business, stick to the business plan. I'll tell you, the easiest time when we file, I don't know, other people might be more, when we file, it's business. And the easiest thing to do is to have a business plan. Because there's times when I get, you know, the soft shoe from tenants and I'm like, oh, man, really, yeah. I look at it again, nope, sorry. Yeah, look good, sound good, but you don't meet such and such criteria. The decision is already made. So if you make the decision when you're thinking about it, and you just say, you know, rent's due on the 1st, it's late on the 5th, after the 10th, you know, if we don't have some money and a written plan, because we don't really need another written agreement. There's a lot of times tenants say, well, we'll write something up. We already did, it's called a lease. You know? We don't need to write something else up. But if they come to you and say, okay, I get paid on Friday, I'll give you 300, 300, 300, and they come up with a plan, and you want to work with them, that's fine. If not, file. The decision was already made. It was made when you were thinking logically, not when they're there, you know, goldfish died or the cat's pregnant or whatever their excuse is. Because there's just far too many people who will say, okay, no, I'm sorry to hear that. Yeah, we can wait another week. You know, how well do you know your tenants? You know, they probably know their brother and their father and their mother better than you. Well, go learn from them. You know, don't lend somebody money, or if they've only been there a month or two, why would you lend a perfect stranger money? You know, just don't do it. It's a business. Treat it like a business. You know, and you know, you can be as lenient as you want. I guess we still have this guy as a client. He ended up beautiful house. He ended up selling to his son-in-law or something. I remember sitting there and I was just shaking my head. The guy is 70 years old, nice as could be. The house right next door, he's renting out. And I'm like, oh, you know, they owe you money. You know, we probably should go to district court. She drives me around sometimes. Okay, you know, for $3,000, you hire a lot of taxi drivers. Well, yeah. I said, well, you know, everything else. She said, well, you know, I filled the propane tank. She owes you $3,000. You know, why do you? Well, you know, one of them freeze. So his wife walked in. I said, so is this? I forget the word I used, but is this? You know, is this your mission? Is this, you know, you're working, you know, you're feeding and sheltering the homeless, and you know, if that's what you're going to do, that's fine. But if you're doing this as a business, you know, you can't be letting people stay there for free. You can't be, you know, filling their propane tank in the winter time. You know, especially when you look out there and the grandkids have the little gator, the little, you know, Barbie battery operated stuff. It's, you know, it's their priorities. And what happened was, it didn't all happen at once. It was $100, $100, $200, $200, you know, and it just got to the point where they're, you know, back to $3,000, and then and, you know, he had a big propane tank, so he got his fill, and they could piggyback on that and get the cheaper rate. So then he fills that, and then, you know, then I'm money for propane, you know. By the time it was all said and done, it was, you know, almost $5,000 between back rent and propane. It's, you know, it's a lot of money. Oh, time's up. Yes, sir.
Would you recommend a phone call to your tenant right before you go to that hearing, saying if you bring, like, we're going to go through this hearing, beg, borrow, and steal whatever money you can, come to the hearing, I'm willing to tell the judge to forget it if you think that'd be worthwhile? Or what other, I know you don't want to make a second agreement, but what other, like, month-to-month lease do you want to take with you if he shows up and says,
if he's
please take this?
Yeah, if he's taking care of the property, and maybe you know his personal circumstances, maybe there was a family emergency, or maybe he did switch jobs, you can certainly be as lenient as you want. But if you're not really sure about it, I would still have the hearing, because it's, the process is gonna take time, and you can call them and say, look, you know, when we started this business, or whatever excuse you wanna use, you know, my partner and I, maybe it's your wife, or your brother, cousin, whatever, or you can just, that's the other thing, you always wanna be able to have, you know, that one removed, you know, my partner, or we decided, don't ever let them know that you are the sole decision maker. Because if they get to you and start pulling on your heartstrings and get you to say yes or no, it's over. You say, well, I'm gonna go back and talk to the other owners, then you can go back and think about it, and get back to them. But, and yeah, the other owner's your wife, you know, and you already know what she's gonna say, but, you know.
Very true.
Yeah. Why do the tenants have nicer stuff than we do? They got a new carpet, we don't, you know? So, but I would definitely talk to them, and whatever level you're comfortable with. You know, if they're not taking care of the place, go to court. If they are, you could say, hey, look, you know, we're gonna have a hearing on Thursday. Get paid before then, great, we won't have the hearing. If not, you know, there's still gonna be 10 days after the hearing that if you come up with the money, you know, we can work something out. So we'll have the hearing. I'll talk to the judge at the hearing, say that you're a good tenant, you know, that we've talked, and that we can do a pay and stay. So as long as he pays me, he can stay. That way, you know, you're kind of showing some goodwill towards the tenant. You're making an effort. And if he makes an effort at that point, then you can decide what you want to do. But I would never just stop the process or put the process on hold or go through part way and then change your mind without getting something serious from them, because it's just a pain in the neck to start over again. The other thing is, I did touch on earlier, if they break the lease, enforce it. Whatever your lease says, do it. If you go to court today, because the tenant hasn't paid you January, February, March, and April, you'll get late fees for April. You may not get late fees for April, May, and June. There are judges out there that will not give you late fees. You know why? You're gonna do your job. Why should I give you an extra 3 months worth of late fees because it took you 3 months to come to court? So, and, you know, probably talk to Tom again, but if you allow them to break the lease and don't do anything about it, you know, what kind of position does that put you when you go to work? You know, if you've been there, you've allowed them to do something 3 or 4 months, and now all of a sudden you want to enforce it.
I draft language in most contracts, leases included, that say a waiver of a default one time does not constitute that you can continue to do it in the future.
So hopefully you should be able to enforce it. Now, what about if you finally decide you want to enforce it after 6 months because the tenant said something or called you a funny name, or?
As long as your lease says that this is the entire agreement, that nothing further matters, and that your waiver 5 times doesn't mean that you can enforce the 6th one, but that you can't enforce the 6th one, you're not gonna.
Now, what if he puts you in writing and says, I've been talking to you about fixing my house and killing the cockroaches and fixing the window, and gives you that in writing? Now you go to try and enforce it, now it's retaliation. Now you got a whole nother mess. You know what? You just wish you could file on in January. Because if it gets adversarial where you're starting, you know, going back and forth, if they go online and they figure out, you know, how to screw my landlord.com, you know, they start playing the rules in their favor, you know, it costs you a few months. But yeah, that whole retaliatory thing could be a problem too. So it's just best to, you know, treat it as a business. Okay. Well, thank you for your attention. All right. And if anybody has any suggestions for future meetings, I think the board's going to meet tomorrow for lunch. We're going to be discussing, you know, the vision for the group. What do you guys want? What do you want to see? What do you want to do? And the format. You know, you want to do a 15-minute preview of the previous month. It might be a little bit more for the board, so we're going to make sure that you have to be here 2 months in a row to do your preview and then your presentation. Or maybe, you know, whatever. Yeah, so I'd say, you know, talk to some of the board members and come up with some ideas which you guys want to hear about.
What are we going for next month? Well, we didn't release that ties into this, there's stuff that ties into this.
We could discuss the lease. The other thing we were talking about is just having an open discussion, you know, like pick Tom's brain, Dave and Kirby, we could just, you know, whatever. And that might not be a bad idea, just do that next month, just have a back and forth discussion. And we can take some notes as to, you know, what's getting the most interest, or the same type of questions keep coming up. And we can cover some of those things more in depth.
Maybe if you guys wouldn't mind, our first 12 months weren't that tough to come up with the topics because everyone decided we should just kind of lay out the process from start to finish. So remember, 12 months ago we started with Dave telling us why we should invest in real estate, and then we went all the way through the process of how to find properties, agreements of sale, title insurance, flipping, leases, until finally how to get the tenant out when you have to. So this is the conclusion of our 12-month plan. So maybe if you guys would, if we take just a couple minutes here and you flip your agendas over, or if you want to keep your agendas, grab a scrap piece of paper, or there's extra agendas there, and write down 2 or 3 topics or as many as you can think of, and leave them on the table there, that'd be great. Obviously, we don't want to talk about anything that no one wants to hear about. We want to know what you guys think.
The 7 steps. There it is right now. Okay, well, looks like going into overtime. Any other questions or comments?